The Constitutional Court is to consider the Western Cape High Court's ruling that President Cyril Ramaphosa's decision to suspend the Public Protector Busisiwe Mkhwebane was invalid and set it aside. Any court ruling, of course, that decides or declares a decision of the President to be constitutionally invalid must be confirmed by the Constitutional Court itself. The Presidency has reacted to that judgment, saying the Constitutional Court decision will inform its next steps. SABC News reporter Canny Maphanga joins us now live. She's at the Public Protector's office in Pretoria. Any reaction or what the latest is? Is the Public Protector at work this morning, Canny? There's a lot that we're hearing about possible legalities that may follow this decision by the High Court in the Western Cape.
Well, good day to you, Chris, and the viewers at home. As you can see, I am at the Hillcrest Office Park in Pretoria, which houses the Chapter 9 institution that is the Public Protector. Just a quick view before I come into frame. As we can see from outside the gates, it is closed. We haven't seen any activity, and there is no sight of Advocate Mkhwebane here at the offices. As you might know, she did join Full Views Bongiwe for an interview last night, where she stated that following her victory in the Western Cape High Court, that she would return to work today. Now, it is clear and apparent that she hasn't returned to these offices, and when we called her attorneys just a few hours before this crossing with you, Chris, they did explain that there's a legal process that still needs to follow in order for that ruling to stand. Now, just to give you a bit of context, you may remember earlier this year when this Phala Phala saga became public, there were a lot of questions, a lot of investigations were anticipated, including an ethical probe of whether the president breached his oath of office by allegedly concealing the crime. We knew that that would follow with respect to the Chapter 9 institution. Even yesterday, SABC was here with opposition parties in Parliament who were demanding the release of the Phala Phala report so that they could do their work in Parliament to hold the president as well as the executive accountable. As you may know, the Executive Members Ethics Act dictates that within 30 days, once a complaint is made, a report must be released. It's the opposition party's contention that even though the investigation is not finalized, the Public Protector or the acting Public Protector in this case could have released at least a little bit of what they had gathered so far as the investigation is going well. Now, at the backdrop of this Phala Phala saga, which is clearly not going anywhere, as I've explained that yesterday there was some activity outside these offices. You may remember that in June, the judgment does note that the full bench notes that the president received a letter from Mkhwebane about this Phala Phala incident, and it required him to respond within 14 days from the date of June 7. And then June 8, Advocate Mkhwebane, who was still the Public Protector at the time, announced her decision to investigate the incident as she was enjoined by law to do so. Then the following day, she was suspended. It is against that backdrop that the court found that the reasonable person could conclude that the president was conflicted at the time that he made the decision, and as a result, a reasonable person may come to the conclusion that the decision was irrational and therefore it was declared invalid and set aside. However, this does not have an immediate effect right now. As you've stated, Chris, the Constitutional Court still needs to give the final nod. As we understand, there is a possible appeal on the table regarding this, but with respect to the presidency, they are going to be guided by that Constitutional Court process. They have acknowledged that they noted this judgment, but they'll go forward with the Constitutional Court process that will follow. As of now, Advocate Mkhwebane has not returned to her offices. Over to you in studio, Chris.
Canny, just before we let you go, yesterday indeed I did see you with those opposition parties who are calling for something with regard to this report to be released. Does the decision of the Western Cape High Court add some sort of weight in declaring this invalid versus what these opposition parties are calling for some kind of something to be made public? Because with everything that has been said regarding this Phala Phala saga, there have also been accusations that the Public Protector's Office had not done enough, or speedily so, and with the extensions that were granted as part of what we saw, that something needed to be done, or at least by now, something should have been released pertaining to this report. So does the Western Cape High Court decision somewhat give some weight to what these opposition parties were saying yesterday?
Well, Chris, not necessarily. The Western Cape High Court decision deals with the president's decision and the rationality of it. What the opposition parties came here to discuss was the release of the Phala Phala report as guided by legislation. The Executive Members Ethics Act states that within 30 days that report must be released. Now the Public Protector's defense, or rather when we spoke to Opa Sekhwale just before that march, it was understood that complex matters can take more than 30 days, and in the history of the Chapter 9 institution, they have not been able to release complex matters such as Nkandla within 30 days. Now it is the acting Public Protector's contention that she would rather release a report that has all of the details and could not possibly be challenged in courts. So she has 7 days to respond to these opposition parties' demands, and with respect to Mkhwebane, that is a separate process that will be guided by the Constitutional Court.